court.
As you read the Delaware law, do you think it is even purporting to say what must be done in federal court?
We do not. We think it actually says that Delaware courts are to apply this rule.
And let me ask you this. If you had to concisely say, you know, as Justice Sotomayor said, you identify a number of different rules that you think preclude application of this Delaware rule in federal court. Let's put aside the Rule 11. Let's say I'm not persuaded by that. Concisely say to me, if we were going to write this opinion and we were going to say that under Hanna versus Plumer, there's a direct conflict here and so the federal rule has to apply, concisely say what you think the best rules to point to were. What would the reasoning be?
So Rules 8 and 9 set forth what a plaintiff must do to state a claim in federal court. And Delaware's law adds an additional evidentiary requirement that you have to...
But 8 says just pleadings, and an affidavit's not a pleading. So tell me why Rule 8 precludes this.
So Rule 8 precludes this because Rule 8 implicitly forecloses the application, the requirement that you come to court with a bunch of evidence, just as it would preclude coming to court with new particularity requirements or other requirements that you would have to put into the complaint.
How would your position, or what would your position be in, say, states that have these mediation or arbitration or board of review requirements to file med-mal claims before they come to court?
Those pose difficult questions for conflicts analysis under the federal rules. Each of them is different. They have very different requirements. Some of them are non-binding. Some of them create evidence that is then used on the merits later in the case, but because it's serious evidence against the plaintiff, it deters the suit. So it's not clear that all of them would pass, but I think many of them would pass.
But you think that deciding your case does not require us to say anything so broad as to say that states can't apply any kinds of procedures that try to address the problem that the Delaware law is trying to address?
Absolutely. Not only that, I think that this really leaves open an incredible array of ways that states can address the problem of medical malpractice suits.
Can you give some examples?